Scholars who have spent a long time studying the traditional reforms have ultimately come to the conclusion that if you want to do something interesting, you have to look elsewhere. So where are some of the places that people have been looking outside the traditional group of reforms? The first of the ideas is an administrative compensation system, often called a health court, although that term is somewhat misleading in that what we're talking about here isn't a court at all. The notion is that if we think the judicial system does such a lousy job of resolving medical malpractice claims, let's get them out of there. Instead, let's set up an administrative process through which people can file a claim for compensation like they do when they're hurt on the job, workers' compensation, like they do when they want to file a disability insurance claim, Social Security disability insurance, or when they're hurt by a vaccine, the Vaccine Injury Compensation Fund. This idea has a few fundamental suppositions. One is we take these claims out of the judicial system and we put them in this non-judicial process. We try to make this an exclusive remedy, meaning people don't get to choose whether they go to court or they go to this process. Ideally, they would go simply to this process to avoid adverse selection in and out of the system. And there aren't any juries in this process. We would instead have some kind of expert adjudicator. Now, there are lots of reasonable concerns about what might happen if you put a doctor in charge of this type of system. So one idea would be to have a skilled and experienced administrative law judge who has long experience in adjudicating medical malpractice claims. Now, how do you make sure that they decide in an informed and reliable way? Well, instead of allowing each side in the litigation to hire their own experts to present their own version of the truth, why not have neutral experts that work for the compensation system? They would advise the adjudicator on the clinical issues in the case, render their own clinical judgments. They would have been serving in the system for a long enough period of time to be able to remember past cases and compare and contrast, to think about what was awarded in past cases. And they would be assisted by two crucial things that are missing in our current system. One is a written record. Most malpractice litigation has zero written record to help the next judge or jury decide the case. So why not instead maintain a database of other cases involving shoulder dystocia to a newborn and what caused them and what happened in those cases? And the second is a list of the types of injuries that we see commonly in the malpractice system and that we've already figured out are usually avoidable. We might call these ACEs, or avoidable compensable events. Those kinds of cases shouldn't need a long, drawn-out investigative process. If we can make an ex-ante determination they're the kinds of things that should be paid, we can get people money quickly and expedite those cases in the system. The third crucial element of this system is that we get rid of the negligence standard. Let's just admit no one knows what this is. It causes much more problems in medical care than it provides benefits in terms of a system that renders deterrence and compensation effectively. Instead, we might replace it with any number of alternative standards. Some countries have just chosen to compensate all injuries that are due to medical care, whether or not they're negligent or avoidable. But the standard that we and my colleagues and I think makes more sense is called avoidability. It's in use in countries like Sweden and Denmark in their compensation systems, and says, ask not whether this is customary care or substandard care, but is this the kind of injury that would ordinarily happen in an optimal system of care or in the hands of the most experienced provider? If what we want the system to do is to prevent preventable events, shouldn't the compensation standard be preventability rather than negligence? The fourth important element is some guidance on what these cases should be awarded in terms of damages. It's astonishing that juries are sent out to deliberate in malpractice cases with nothing more than an economic expert's evaluation of the out-of-pocket and future expenses and an admonition to do what you think is right and reasonable in terms of pain and suffering. Wouldn't it make more sense to make some judgments together about what the value of different kinds of states of ill health and disability are? There's lots and lots of research from decision science that can help us do this, to value different types of injuries and come up with a range for non-economic damages that decision makers can use to set damages awards. Why is that important? Two big reasons. One is that in our current system, people with similar injuries take home wildly varying amounts of money for no apparently good reason. And the second is that it's really important to help insurers estimate their liability from year to year to know what the value of a case is going to be worth. So if they have that information in hand, we should expect insurance premiums to go down because part of what they charge represents their uncertainty, the risk they take when they assume liability. If we can reduce that uncertainty and risk, we should be able to reduce premiums. So giving some guidelines or a schedule of non-economic damages could be a big win here. And finally, the fifth pillar of this system is to make the system work as a system for surveillance and analysis of medical injury. We do this by centralizing information about claims in a single entity and creating this written record. Right now, information about serious medical injuries is in the hands of hundreds of different insurance companies. There are a few efforts among these insurers to pool their information and do group analysis, but most of them hold it tightly and do surprisingly little in the way of analysis, certainly at the level of surveillance and proactive tracking. So by centralizing this information, we create a potentially powerful new information resource to learn about serious events that go wrong in medical care, the patterns of those events, and what could prevent them. So these are the pillars of health courts. Now, what do we know about how well this idea works? Well, the answer is not as much as we'd like. There are lots of analogs out there, but no on all fours examples of what this system would look like here in the US. So we've got several foreign experiences that I'll talk about in just a second. Here in the United States, we actually have two states that have long had administrative compensation systems for severe birth injuries that involve brain damage. They're not exactly applicable because they're so-called strict liability systems. They don't award damages on the basis of any finding about the quality of the care involved. But they're useful to look at. We have a workers' compensation program in the United States that has long experience to draw on, a vaccine injury compensation fund, lots of simulations that would show us how a system like this would work, but what we don't have is a good demonstration project. Many of us have been working to get those pilot projects for many years, but because this would be an exclusive remedy, it's really difficult to test as a pilot project. You have to get some state to agree to deny access to its judicial system while the experiment was running. So the question for policymakers for a long time has been how much evidence is enough to move forward with that kind of policy experiment. And to my mind, I understand this is a very far-reaching and to some minds radical proposal, but the experience that we take from foreign countries is actually pretty compelling. When we at Harvard did a study of several different countries' experience with this type of system, here are a few of the things we found. First, it does seem to open up access to justice. If you look at the rate of claims across these different countries per million persons in the population, it's much higher in the countries that operate administrative compensation systems. Now, this is a bad thing from the perspective of physicians and hospitals and their insurers, but it's a good thing if you know anything about the epidemiology of malpractice claiming. It means that more people who are entitled to compensation under the rules that we've set up are getting into the system. Surprisingly, the claim success rates aren't markedly higher in other countries than in our own, perhaps because our own seems to attract so many claims that are non-meritorious. The most notable thing is that we pay a lot more in our system than other systems do. And this is where the experience of other countries is not especially helpful to us, because the other countries have other forms of social insurance that take care of injured people. First and foremost, they use their administrative compensation systems for medical injuries as a kind of backup or secondary payer. So those amounts really aren't comparable. But I think it's fair to say that particularly in the pain and suffering realm, the valuations that they place on injuries are much lower than what is placed here in the United States through juries and the settlements that are made in the shadow of a jury trial. One thing that's notable about the foreign countries is that the rates of appealing decisions are quite low. And most strikingly, look at the overhead costs. Again, in the US, we spend about 54 cents on the premium dollar just litigating claims. Other countries have been able to get these overhead costs down a lot, which means that for the same amount of money that we're spending on our system, we could be compensating a lot more people with less waste. So to my mind, this is really provocative evidence that justifies at least a policy experiment with this type of system. There are a lot of arguments in favor of the system. Speeding up the adjudication of claims is good for everybody, claimants and defendants alike. It promises higher reliability because of the use of guidelines, damages schedules, past decision-making, and neutral experts. It promises expanded access to compensation, which again, from the perspective of defendants is not a good thing, but from a fairness perspective, it is. And believe it or not, there is the promise of cost control, even though we're opening up the system to more claimants, because we can control the amount that are paid in the cases. Instead of turning that decision over to a jury, why should we not decide as a society how much we want to spend on medical injuries and set those damages guidelines accordingly? Finally, there are just huge prospects to improve deterrence and patient safety in this system. One reason is that a lot more instances of substandard care would result in a claim, so that deterrent signal would get a lot stronger. And another reason is that by getting rid of negligence and all of the stigma and adversarialism around negligence, we have now the promise of opening up physicians' willingness to talk about errors, to be more candid among themselves and with patients about things that go wrong in healthcare. So what are the prospects for this reform? There are a lot of political reasons why it's appealing. I think the strongest one is that it does offer a quid pro quo for almost everybody who's got skin in the game here. It offers something to patients. You can have a much higher chance of getting into the system and getting compensation if you were negligently injured. It offers something for insurance and doctors. You won't have these gigantic awards. You'll be able to predict what your awards will be. No fights over negligence. And it has a really strong alignment with the current push in health policy for improved patient safety. On the con side of the ledger, though, there are some really significant challenges here. One is that if your primary goal is reducing the cost of the systems, this is probably not the reform for you. At best, this would probably be a cost-neutral reform. It would improve lots of things about the system, but wouldn't radically bring down malpractice premiums. And in the absence of some kind of test here in the US, the risk associated with this reform for insurers is pretty unquantifiable. So you need a bold insurer who would be willing to try out this kind of a system. But the biggest challenge really is political. There is a very strong lobby in favor of preserving the right to jury trial, which is, to be fair, under many state constitutions, a constitutional guarantee. So there are some settings in which this kind of policy experiment would be a non-starter just for legal reasons. But even in the states where it's a possibility, the trial bar has a very strong hold on a lot of legislators, and a lot of legislators are themselves lawyers and really believe in the jury system. All evidence to the contrary, the fact that most plaintiffs don't win jury trials and don't do well in front of jury trials will not dissuade a legislator who believes that preserving this system is really fundamental to looking out for the little guy, and that we have to avoid letting the system be captured by industrial interests. Figuring out a way around those objections has proved to be a very, very big challenge for this proposal. Next, I'm going to talk about some proposals that have really captured people's interest and attention, both for their potential to address some of the cost problems in the system, but also because they promise to address some of the deeper dysfunctions in our system.